Yeah.
Good afternoon and welcome to Grand Rounds. I'm Kelly Forst, an attorney with the Collaborative Family Law Group of Central Florida and one of the co-chairs of the Grand Rounds Subcommittee of the FACP Outreach and Practice Group Committees. We're excited to welcome you to session 5 of Grand Rounds, a monthly lunchtime session showcasing a different Florida collaborative practice group each month. The first portion of the session will be a presentation, and the balance will be a discussion period where we will troubleshoot and brainstorm solutions to the unique problems presented in the session. If you have questions during the presentation, please place them in the chat and we will kick off the discussion period with them. Once the Q&A session begins, please raise your hand by clicking at the bottom of your screen in the reactions box. For this session, the presenters have selected the topic, the gray divorce, but we'd like to ask you to submit any issue you've had to address in the collaborative process, whether substantive or process-based, with a short fact pattern for us to use as the foundation for future sessions. You can email them to me or to Liz Riberedo, my co-chair, and I will place our email addresses in the chat. Thank you all for coming, and I'm happy now to introduce our panel of presenters. Dr. Brad Broder is a psychologist who's been serving the people of Sarasota, Manatee, and Charlotte counties since 1996. He specializes in couples and family therapy, but also does treat individuals. In 2017, he earned the prestigious Child Advocate of the Year Award presented by the Child Protection Center of Saratoga County. Sarasota County. He earned his doctorate degree in clinical psychology from 1987 from Hofstra University on Long Island, New York. He has had a distinguished career as a psychologist, educator, mental health clinic administrator, and now as a collaborative mental health professional. Dr. Broder presently serves as a psychological consultant to both the Sarasota and Manatee Counties child protection teams, conducting evaluations, providing in-service trainings, and conducting seminars on a wide range of topics that address trauma and psychological abuse. Attorney Sharon O'Day has represented clients in all aspects of family law since 2001. In 2012, she made the professional decision to limit her practice to assisting clients in resolving their divorce or other family matters without litigation. She became a Florida Supreme Court certified family mediator in 2006 and a circuit civil mediator in 2011. She is also accredited by FACP as a collaborative attorney. Sharon graduated from George Washington Law School in 1987 and is a member of both the Florida and the Maryland bars. Prior to settling in Florida, she lived and traveled around the world while working for the United Nations High Commissioner for Refugees. Bob Piper is a CPA and member of Piper, Hawkins and Company. He's been a licensed CPA in Florida since 1978. Previously, he worked as an IRS agent for 5 years. He is certified in financial forensics and is a certified valuation analyst. In 1976, he received the Elijah Watts Sells Certificate of High Grades on the CPA examination. Bob was trained in collaborative practice in 2012 and has worked on many complex collaborative cases. Welcome to all of our presenters, and now I turn the presentation over to this distinguished panel.
Thank you. I'm going to start the presentation part of this morning or this afternoon by giving you a brief summary of the facts. Hopefully you all received them and had a chance to look them over before this session, but I know that we're all busy. So just in case some folks didn't, we've divided the facts into 3 sections. And so I'm going to start off with the first section, give a brief overview of it, and then open it up for the discussion among the professionals. Then we'll go on to the second part, the third part of the facts pattern. But I'm really hoping that this will be an opportunity for us to share some ideas. I'll tell you, the fact pattern I developed was from a number of different cases that I've had lately. We talk about gray divorce in Florida a lot, but it seems lately it has really become a predominant part of my practice and brings its own challenges. And so I sort of melded a couple of cases together because I wanted to bring some of the different problems that we experience when we're working with couples of advanced years in the divorce process. They have some unique issues. We don't have to deal with the children's issues, but we may have to deal with some other things. So that having been said, the facts are generally this. Sally has contacted an attorney. She is currently 87 years old. She has one adult son from a prior relationship. She's married to Thomas. Thomas is 88 years old, and he has been married twice before. This is his third marriage, and he has 3 adult children by prior marriages. Sally indicates that she's become very concerned about Thomas's mood swings, and it's just too difficult to live with him any longer. So while she still loves him and wants an amicable divorce, she feels like she needs the divorce now. She talks with the attorney about collaborative and agrees that this would be a good option for them as long as Thomas agrees. She's given a list of other collaborative attorneys in the area. Thomas meets with one, decides to hire that attorney, and they're going to proceed collaboratively. The attorneys then agree upon a financial neutral, which in this case is Bob Piper, and they agree on a mental health professional, which in this case is Dr. Broder. And so the couples are advised to meet with each of them before they go to their next step. When Sally meets with a financial neutral, it turns out that she really doesn't know much about the finances. She came into the marriage with about $1 million, but she kind of just turned it over to Thomas because he was always very good at finances and she's very comfortable with him handling it. Thomas, when he meets with Bob, is very scattered, doesn't seem to have a good grasp on things, is really struggling with giving information about the financial accounts and such. And so there's some concerns about that. He does say that he owned the house when they got married and that they're still living in that house. And he knows that he had about $1,200,000 when they got married. Meanwhile, when the couple goes and meets with Brad finds that Sally indicates that she's very worried about the mood swings and the short temper that Thomas has lately, and that he's been forgetting a lot of things. He's forgetting his medications. He's forgetting to tell her about doctor's appointments, and she's worried about that. She's also extremely emotional when she meets with Brad and very frightened about her future. Thomas also, when Thomas meets with Brad, he's kind of the opposite of what he was with Bob. He seems very coherent. He seems very calm. He did say that he's had some issues with temper lately, but it's mostly because Sally can't keep the house clean anymore and she refuses to have a maid in. But he does say that he's worried about Sally's drinking lately and that he's worried that that's contraindicated with her medications, that she's been drinking and takes medicine for depression and anxiety, and sleep and anxiety. And he's worried about her drinking. So at this point, the team has their first meeting as just the professional team, and we have to discuss a number of things. So from that, we're looking at what issues would be raised. So Bob and Brad, you're going to be talking about what issues would be raised at this first professional meeting.
Well, let me chime in then. For this population, the gray divorce, it's very clear the main concern is kind of a legal one, and that being we don't want to settle on something and have someone challenge the mental competency of the individual or one of the other parties. So we have to take that into consideration. So what I've done in my practice for my protocols for getting the original consent or the professional service agreement that I have is that I've set it up that I ask the people to agree or consent to allowing me to speak to other family members. Secondly, to allow me to conduct some sort of screening instrument, which is usually referred to in my field as the mini mental status examination. And thirdly, to agree to be open to the idea of outside referrals in case there are signs of something like dementia. We'd want to have that more thoroughly evaluated, perhaps by a neurologist, or at least get other professionals involved potentially. So we're not talking about everyone has dementia, but prevalence rates on dementia, such as that it increases with age, obviously, and the cutoff point in the professional literature is usually age 65. We're better than 16% of people suffer from dementia. Of course, that increases up to the age of 85, where it's over 25%. So in this case, you could see, given the age of Sally and Thomas at ages 87 and 88 respectively, they would already be considered a risk for having some sort of cognitive decline, which may just be age-related cognitive decline. For example, age-related cognitive decline would be the tip of the tongue phenomenon. Many of us have that at any age, right? We know the word or the explanation or the place we're going to or whatever, but we just can't think of it, but we have it in our head. So what we're concerned about here is getting the people to agree that we're going to have to kind of approach this collaborative process a little bit differently. So that's first what I address with them in my protocols. But then, given the information that I would usually receive from the attorneys, in this case, what I had received from Sharon and some of the concerns, in talking with Sally and Thomas, we have things to evaluate. So I'd ask you to think in terms of threes, because the interview process, first, you'd want to make sure you had an assessment of what kind of medications they're taking, the regularity with which they're taking the medication, who's prescribing the medicine, the dosage, do they remember the dosage, are they aware of what they're taking the medications for? So that has to be included, different than perhaps, I mean, that's a general question you might ask anyone, but perhaps if someone's 35 years old, they're getting divorced, it's certainly not as big a concern or a point of emphasis. Secondly, you want to get into more of what we refer to in my field as the ADL, activities of daily living. What are the household conditions? How do they function, in terms of their morning routine, taking care of the home, bedtime rituals, whatever is going on there. As we learned in the situation, Thomas had complained that now Sally's not able to maintain the upkeep of the house. And we've all heard those classic examples where something's left on the stove and the burner's never turned off. And then we have all sorts of potential fire hazards and safety hazards like that. So that has to be assessed. And then thirdly, we're looking at the use of substances. Again, Thomas complained that or had the concern that Sally, his wife, was drinking too much, and given that she's on medication for anxiety and depression, the combination of those two is very worrisome. So the assessment process or initial intake interview that the mental health professional, or as we prefer to be referred to as the facilitator of the group meetings, it takes on a little bit more of a, I must say, almost a diagnostic appraisal, because we're concerned about cognitions. Obviously following the Dusky standard, we want to make sure that the individuals can communicate and consult with us and their attorneys. We want to make sure that they have a good comprehension or understanding of the facts related to their situation, notably in this case, the financial situation and how they can take care of one another. And thirdly, under Dusky, of course, would be an appreciation for what the things are that they're signing off on in terms of whatever compromises or agreements they come to. So my role with these two was to kind of flush that all out, because in this case, it was very important to be able to talk to their family members. We had Sally's son and Thomas's daughter needed to be kind of what I'll say is kind of calm them down so they stayed out of the fray, so to speak. So we found that would be very helpful under that. So having taken care of that, then Bob was able to talk to them more directly. So I'll switch over to Bob then.
Okay. It's a highly unusual case that I really haven't ever dealt with these people of this age. I mean, I've had maybe one that age, but having two people in their very late 80s. So the fact patterns that you were given from a financial standpoint aren't very much. They're just, some of the assets the parties had coming in and where they stand today. And while we definitely will have to deal with those, I don't know that those are the issues at our first meeting that we're kind of addressing. What I want to know financially and have on the meeting table for the discussion purposes is to know a little more about the parties' income and their needs and how they're going to live. questions like, can Thomas live in the house? You know, what's the value of the house? Will the house need to be sold? Can he live in that by himself? Where will Sally live? Is she ability to live by herself? We need to know some of those questions so that we can develop. Sorry. We need to develop what their needs are going forward, their monthly needs are, and what kind of income sources they have to meet those needs, such as, it's not in the fact pattern, but they might have pensions. So I know they probably get Social Security, but what amount is that? What's their pensions? And where will there be enough income? And then we can start addressing the assets. And there's definitely issues to resolve there, as you can see from the fact pattern, where Thomas has probably, based on that, he's lost 200,000 of his assets in value, but there's 500,000 joint assets, and Sally's lost 700,000. And from the initial discussions with the parties, it looks like that Thomas might have taken Sally's assets and converted them into joint assets. So we need to address we're ultimately addressing that, probably not at the first meeting. And what other financial topics I would be discussing at the first meeting really would depend on what financial information I receive from the parties beforehand. You know, if I don't have any financial info too much, there's not a lot of topics we can discuss. We can discuss what we will need to be gathering. But as I said, I still think we need to get an understanding of where will these parties be living arrangements going forward because of their age. Can you assume that the husband's going to live in the house? And, you know, when I first read this, I don't know if Brad mentioned this, but when I first read it and on the fact pattern, because it's not a case, I haven't had these fact patterns personally, but it sounded a little bit like the people were kind of got annoyed each other with some of the housing arrangements where she doesn't have a maid. She can't take care of the house. He's mad because the house is kind of messy. Maybe these parties need a assisted living facility, and it could be a discussion whether or not Brad would discuss with them whether or not, if the living arrangement could be changed, would that improve the marital relationship? And then if that was, I mean, we might not have to, you know, we might solve their problems without actually a divorce at the end. But anyway, I'll turn it back to Sharon. I have other things to talk about, but we'll get to that later.
From the facts that we have so far, Brad, this is really, I think in this case, the MHP is such a vital element of this. If it turns out where Bob says that he met with the husband in the afternoon, and that's when he was very scattered and having trouble focusing and wasn't able to give the financial information, you had met with him in the morning and you found him to be calm and coherent and things. First of all, is that a red flag to you? And then the second thing is, with all of the facts that you have, are there some accommodations that we could have to help these parties move forward that we'd want to consider, given their ages, given their clear, you know, issues that they're having with emotional health, as well as maybe some physical limitations they may have? Are there things that the professional team should be looking at to assist to make sure that we're accommodating them well?
Well, I think getting back to the first point, if Bob was experiencing Thomas in a much different way than I had, or for that matter, Sally, then that would be a very significant fact, because you'd be concerned then with the person's ability to sustain that mental focus, whether it be to communicate or again, in my world, what's referred to as executive functioning, the ability to be able to process information, you know, maintain that, because the big issue here is going to be one of memory or memory impairment or memory loss. So if they're able to maintain that focus and remember things, but are they able to retain that information so that in the next meeting, in this case, then like with me or with you or with Bob, and they haven't maintain that information. We have signs of forgetfulness or memory loss, which again is an indicator of cognitive decline, and that would be worrisome. So that's where we might want to then invite an outside professional to evaluate further, so we maintain our objectivity or our role of neutrality in the collaborative process, but at the same time, see if we can't have that addressed through the person's physician or neurologist to better address that. Much like to your second point, in terms of problem solving, Bob's idea of that maybe if they had an assisted living and they had enough assistance, then given the fact that particularly Sally had professed that she still loved Thomas, that there could be a way to perhaps salvage their relationship, their marriage, and we problem solve that way. But I think we'd have to eliminate some of these other worries, some of these other concerns with respect to cognitive functioning.
Mhm. I know in the cases that I've had that this case was based off of, some of the things that we in the professional team talked about was that the in discussing with both of the parties, we learned that the husband particularly had better function in the morning. He was he was alert and awake and seemed to be doing really well in the mornings. By later in the afternoon, he started to really get tired and become more short-tempered and things like that. So we made sure we had our meetings in the morning. We made sure that we were able to keep the meetings shorter. We actually shortened the meetings so that both of them wouldn't become exhausted by the process itself. So we really kept the meetings more to an hour, hour and a half, to keep them on task, and made sure we had, some food available, and we're meeting those kinds of things that for a younger couple weren't as big of an issue, but for an older couple really need to sort of be more attuned to what's going on with them. We also had to make sure that we were meeting in a place where it was accessible for somebody who didn't have to climb any stairs or go through any kind of difficulty getting in from the parking lot. If you're going to be doing Zoom, then you have to make sure that the couple is comfortable with Zoom, which, applies to anyone of any age. But again, we know that younger folks may be more comfortable with the technology that we're using. And that if you have someone who's not as comfortable with the technology that you're using, that you have a way to make sure that they can get onto Zoom and move around and hear things and all of those things without having their child in the room with them, guiding it through the process, because you don't want the children attending. So those are some of the things that we came up with as well in discussing at the first meeting, things that we would have to address for this couple. I was very concerned as the attorney that, as Brad said, I don't want to get all the way through a collaborative divorce and then have the agreements that are reached thrown out because they suddenly are declared incompetent. The next week, the adult children come in and try to change the process by having a guardianship action started or something. So I really wanted to rely on the mental health professional to guide me on whether or not we had both parties competent to be able to address these negotiations. So assuming that we've made those accommodations and we've talked about, Brad has gotten permission to proceed with talking with any other medical professionals that are involved with the case. We've decided that they do have competency to be able to move forward, that there's no real concern there beyond some accommodation for them. Then the facts go on to a bit of what Bob was talking about, that Bob learns after we've had our first full team meeting and is meeting with them with more of the information. He learns that Sally's accounts, she had $1 million when they got married initially, but her account was used to buy a jointly titled boat and timeshare. And then a number of her other accounts have been commingled into the joint accounts, which now are worth about $500,000. Meanwhile, Thomas's accounts have been were in IRAs and retirement style accounts, and he still has about $1 million left in his accounts. And then they have the house worth which is worth about $700,000. That was his premarital house. And Thomas indicates that he wants to be fair to Sally and he wants to make sure that she's okay. But we're looking at this kind of assets at this point. So Bob, you started to get into this a little bit, but if we've already had our first meeting, we've had a meeting where we've talked about them wanting to be fair and come up with something that is a solution. We talked a little bit about how you would approach this financially for them. And are there any options, even outside of this fact pattern, that you think might be something that professionals might want to bring up when we're looking at this, assuming that they don't have anything more than Social Security, you know, they don't have pensions coming in and such? What would be some of the options that you might want to raise with the couple when we're talking about these finances?
Well, I can give you some options, but one concern, I see some of the questions that people are asking us about the interrelation probably with the family members coming in. And that's, I think, a concern in building those options. And I don't know, I think maybe you'd be better address whether how you bring them in, but I know they're a big part of this because they're just like work I do for estate planning. I still do a lot of tax work, estate planning with clients, and even people that are married when they're on second and third marriages and they're dying, and there's big fights about what happened to my mom's assets or my dad's assets, and how did the other one get a hold of them? And so there's big wars about that and problems, and I think those are problems we're going to have to address in trying to resolve this. And so in some regards, input from family members are going to be somewhat important, or at least they need to be apprised of what's happening so that mom and dad are good with it at the end, and hopefully to the large extent the family members are, so that we don't have them fighting later about it. But some things you can do in fairness, I looked at it like if the joint assets, it looks like it's come a lot from Sally's side, and that possibly, you know, it's more like an equitable case, not necessarily marital versus non-marital. If Sally got all of that 500 back in a settlement, she would have roughly 800,000 of assets. She came in with $1 million. She's down 200,000. And Thomas, he's down. He has a 200,000. He had $1.2 million in investments and retirements, and he's down to $1 million, and he still has his house, which whatever there. So they both would be down about 200,000, which seems reasonable. Of course, Edward still has more. He has like 200,000. Still have 200,000 of investable assets more, and he has a house, which we don't know in the fact pattern what it's worth, and what if it might be at a time, and if they were divorced, that he can't live there anyway. It could be sold. Maybe it's an expensive house, and there's a lot of additional value there that we can look at towards trying to structure something to make sure there's income available to Sally too. Now they're both 87, 88. Either one of them could die any time. So one thing we've talked in another case I had is that if there was the ability that Thomas had considerably more assets, but we could form maybe an irrevocable trust in case he died, where Sally would continue to get income from that trust to help meet her needs. And then when she passed away, those assets go back to his family, how he would schedule in the trust. So his family is not losing assets, but those assets are still being used to support Sally while she lived, as she lived past his age. So that's one thing I would be at least discussing with them. So trying to keep in mind, not trying to pay a lump sum to Sally, which the family members might not feel kind about, especially if she died before him. You know, if he transferred money, said, well, you need money to live on. We're going to figure out an amount. I'm going to transfer you a sum so you'll have additional income to support yourself. And then after they get a divorce a month later, she dies. Well, his family isn't going to be very happy about that transaction. So, you know, the trust makes a little more sense. If she died, it would revert right back then to Thomas if he was still alive.
Yeah, the trust idea was one thing that has come up in a couple of my cases, and it's worked out well. You can, talk about different kinds of inheritance and things, because clearly their adult children are going to be shadowing that. And that's actually the next set of facts that we had come up. And this goes back to sort of how the whole team wants to handle this, that after they've started talking about some of the finances and things, Thomas's adult daughter contacts Brad and says, after the first meeting, it says that she's worried that her father seems very distraught by the information he's been given. And when he told her about the condition of the family finances, she began to feel that maybe the collaborative process wasn't good for Dad. Meanwhile, Sally's son has contacted her attorney, and he learned about the discussions on the finances and says that he thinks litigation would be better for her because he thinks she's going to get screwed. Soon after the message from her son to her attorney, Sally calls up the attorney and says, no, my son's just a bit of a hothead and I want to stay in collaborative. So this was one of the questions that was raised in the chat as well. How do we handle the fact that we have these adult children who clearly, despite the confidentiality that we've talked with our clients about, the kids are going home and talking with their adult children about what's being said in these meetings. The adult children, their parents are older. They clearly have a vested interest in what's going to happen with their parents' estates if their parents were to pass away. And they're reaching out to the professionals. So what can we do? What should we do? Brad, how would you handle, you started off by saying you would try to talk with the adult children anyway. So how would you handle if you were getting these calls from the adult children at that point?
Well, again, given the dealing with the great divorce as the title of our presentation here, the notion is that we can anticipate these problems. And in fact, they've come up regardless of the age. So we know the practice intuitively tells us that we need to include on some level. That's why I like to have the protocols that the parties have already acknowledged or given their consent, that I could speak to family members. Because number one, it would help in the overall assessment of, how are the parents doing and what is their daily routine. But at this stage, when there seems to be some questions and concerns, and as you put in quotes, their vested interest in this, I would then recommend having a meeting with each of the different adult children, trying to outline their fears, put them at ease, but also then be able to communicate that back to our team so we can factor in their concerns and either address them as part of the settlement or more appropriately provide them with some sort of answer given the input of what, in this case, what Sally and Thomas have agreed to. But I think to keep everyone calm and invested in the collaborative process, it's kind of incumbent upon me, I see in my role, as to meet with these family members and make sure we've heard their concerns, that we can then discuss them as a team and get back to them to keep so that they don't kind of interfere with the process.
If it were determined that while the parties are competent, but they're more comfortable with their adult children being part of this process, would it be something that any of the professionals, Bob or Brad, that you would feel like, should they be signing the participation agreement? Should they be signing some other waiver or confidentiality? Should they be brought into the process in any more formal way? Do either of you have any thoughts on that?
Well, I think, once again, that would be us as a team agreeing that that would be a possibility. Then we present it to, in this case, Sally and Thomas. And assuming we're all in agreement, then we can invite them in. So I don't think that is a problem, as long as we keep it as a joint decision-making venture that we as a team, including the parties, have all understood what would be the purpose, and we're all in agreement as to that objective.
Bob, you have any thoughts on that?
Not really. So I apologize. I was trying to read all the chat comments so that we can maybe cover them. really did.
You guys, we have, so we have 24 minutes left. So why don't we open it up to the rest of the attendees?
Yeah, I think it's perfect timing to do that, because I would love to hear from the attendees if they've had cases like this with the adult children. I'll tell you that my case that we tried to do collaboratively, elderly couple, and then one of the children blew it up, basically sort of stole dad away and ended up going into another situation. So I'd love to hear if there are other people who have had ideas about how to handle adult children in these types of cases.
All right, well, don't fight, just chime in, whoever wants to
You
go.
have to unmute yourself if you have anything to add. Yeah, Helen?
I think Elaine.
Yeah, I was just going to say that Dr. Broder, you did a really thorough job in the beginning, kind of outlining that initial meeting that you're going to have, and very thorough to sort of have every stone unturned. And I was thinking as you were talking, this is really, I don't have an answer. This is really challenging. And what I mean by that is on a good day, elder adults tend to be resistant to let go of their independence. And how many times have we heard adult children sit down and say, Mom, Dad, it's time to give up the car keys. So now you've got layers and layers of adult children. They're not all on the same page because they come from different factions. What happens if some of those kids are already assigned to be, what are they called?
Power of attorney.
Thank you, power of attorney. And then that's going to complicate it because they're going to do what's best for them as opposed to maybe other children, and on and on and on. And then plus you have the couple that are headed into a divorce where trust is at an all-time low. So it's saying, I have to, my head's kind of swimming right now, because even a straight shot, adult children, all from the same marriage, having to deal with their aging parents. So do you bring everybody in? Do you bring all the factions in? I know this sounds crazy to kind of get the adult children on the same page. Maybe
well, one of the curveballs in this fact pattern is the husband's daughter seems, she contacted the MHP, she raised some concerns, but she didn't seem to want to blow up the process. Meanwhile, the adult son of the wife even says, oh, he's a hothead and he's angry. He wants to blow up the process and go straight to litigation, very protective. And so if you invite in the husband's children, you probably have to invite in the wife's child as well, who may be, really problematic. Yeah, Brenda? Oh, you're muted.
Helen has her hand up.
Yeah, Elaine has her hand up.
Okay.
Well, I was just going to chime in the same thing. These people are going to be shadow operatives. And so rather than keep them in the dark, I think we need to be brave enough to bring them in. Now, how and what that looks like, I think the professional team needs to grapple with. Do the lawyers have a joint meeting with the parent and the child? And then, maybe have everybody sit in the same room together, but pretending that they're not out there or that they're not impacting our clients is, I think we've all done this all the time, where we're better off, being brave about talking with our client's permission, of course. I mean, I think you got to start with your client's permission, and then bring them in, and maybe, yes, have them sign the collaborative participation agreement. Maybe when that hot-headed son here's the cost of litigation, he'll change his tune a little bit.
Right. Well, one of the things that we did in one of my elder cases as well was we brought in a neutral elder attorney to talk about whether or not there were other benefits that these folks could consider. There were some veteran benefits that they were completely unaware of that could help the husband. There were some other benefits. So bringing in a neutral elder attorney who knew that he wasn't going to be an attorney for either of the parties, but to just be an advisor to the team, we found to be helpful as well. So that's another expert that could come in. But the question is, if the children come in, would they also need their own collaborative attorneys if they have a vested interest? And one of the questions that was raised was also, if there's closely held family businesses or already established family trusts, they may have a legal vested interest in the outcome of this. Do they need to have their own collaborative attorneys? Or are we going to, have a conference room of 20 people?
Let me piggyback on that if you don't mind,
Mhm.
because I think getting back to, we love the collaborative process because it's such a healthier way, both financially and emotionally, to help people divorce. And of course, that becomes the goal of divorce. But getting back to Bob's point about problem solving for these 87, 88-year-old couple, if we were to first talk with the extended family about the nature of their marriage and we kept them together by recommending an assisted living facility, then we truly are helping this couple, maybe not with the ultimate goal of a divorce, but with a healthier goal of they maintain their marriage and they just have these other supports. So I think before we were to bring in the family, maybe the facilitator, mental health professional would meet with the children to assess, is it their sense that their parents actually could still stay together? And we get back to Bob's point about problem solving, which is just, I think, excellent point. Brenda, we kept you waiting.
Brenda, you've been
You're up,
trying.
Brenda.
No, you haven't kept me waiting. I've been on mute and I've unmuted, and I'm the resident 82-year-old in the room. So I'm going to address some of these issues. I appreciate Brad's first meeting description, but having listened to the discussion, I think that the team and the couple need to have the elder law attorney at the first, just as a consultant at the first meeting, to prepare the couple for the issues that they're facing, given their age and given the family members. And if that happens in the first meeting, the couple might determine which of the children they need to bring in. I'm not opposed to the children participating, but I think everyone is operating in a vacuum. And unless the elder law attorney can advise, I think they will continue to operate in a vacuum.
And it's true that I think as we've dealt with our own parents and also as we see in our cases that we work with, identifying perhaps a child as the representative, if you have more than one children, there usually is a child who maybe has taken over the caretaker role in the family for their parent, or who maybe has been more involved in the family business or things like that, that may be the appropriate person to bring in, rather than bringing in all four children, or, having decision by committee. We know that's problematic, but we might be able to bring in the representative children, adult children, if they were to come in. Randy indicated that she was very concerned about bringing the adult children in. I don't know if, Randy, you can comment on that so they see her in the car. You're on mute too.
And I think Tanya had a question.
Yeah, so I was, thank you. I am hearing, first of all, this is a beautiful case and your presentation is wonderful. And like Helen said, seems like you've covered all the bases really, really nicely. I have a little concern with that said, that we're almost disrespecting this couple's competency and desire when leaning too heavily on the children, even if that's where they want to be, because, even in terms of questioning the couple's decision to divorce, it's their decision to divorce. If, we were dealing with concerns about their competency, I would question that. And I'm not suggesting, much like Elaine said, I'm not suggesting that we push them out, but I am suggesting that we determine what it is the couple really wants, and do they want their kids involved? And I would approach it by talking with them about, the kids seem to be at odds, which is not unusual, particularly in this kind of a situation. So wouldn't it be nice if the collaborative process helped bring the family together and made things very clear before either of them or both of them pass, so that after there's not a financial war, there's not questions about their decisions. I mean, they have a beautiful opportunity to make their decisions clear before they pass. So I would just build on the fact that they are competent, according to Bob, and I trust you based on everything you've talked about. And that's what my thoughts are.
Tanya, you had something?
I did. I think that, we don't want to take competency and the couple's independence for granted, but the reality is in many of these cases, the parents have really become dependent on the adult children and can actually be frozen and not move without the child's input. I was involved with a case just like that. And we actually brought the adult child who was unfortunately actually controlling the mother into the process. The team went round and round about it, but that was really the only way for us to get the mother to participate. I mean, she was holding the team in the process hostage because she just would not move. We did have the adult child sign an NDA, and we were able to resolve the case. So, the reality is in these gray divorces, you're going to have children, adult children who are playing vital roles, and we should just see how we can use them and protect the process and, protect the clients.
Mm-hmm. One thing that was raised was getting the estate documents and the powers of attorney and all of those things, because I hadn't done that as an attorney in my cases, but it sounds, what I'm hearing and thinking about as we're going through this, it sounds like that's a very good thing to have as well, just to sort of assess what their thought patterns had been, especially since this was obviously a later divorce in their 70s when they got married, that maybe we needed to have, I needed to consider whether had already given some powers to their children that may be of concern. Roxanne, you had your hand up.
Yeah, I was going to play a little bit off what Randy said. I think we have to start with the concept that these two adult people, as old as we are, maybe decided that this is what we want to do. And we get their thoughts about their children and how their children are feeling about this, because we know from particularly the research and the writings that Carol Hughes has done, that these older children are also having a lot of emotional responses to this. We are not looking at them necessarily with a child specialist because they're considered to be adults, but do we need to give the parents some opportunity to determine if and how they want their kids to be consulted, and then with them decide what's the best way to have that happen? Should they be speaking to someone different? Do they have opposing views? Is it that one child is siding with each parent? Is it one child that's overpowering the entire team? And maybe that needs to be looked at by somebody who can present that to the team, who can then determine how to handle that with the parties, because it is their divorce, I think, as was stated.
Well, clearly this couple has brought their children into the process in the sense that they're both speaking with their children, lamenting about things, and then the children are taking it upon themselves to call the professionals. So the
Right.
children, the parents obviously told the children, oh, well, if you don't like it, call my attorney or call the mental health person or whatever. So they're involving the children. And I think at that point, we as professionals have to recognize that the parties have involved their children. If we had discussions about this as a confidential process and, they're going outside of the protocols. So then we have to decide how we as professionals are going to include the adult children in the process, so that they're not just each going off and whispering to their kids about what's being said. Make sure everybody's on the same page with this, because, that's the other problem, is these folks who clearly, are competent to be able to sign an agreement, but may have some memory issues, some issues with being able to articulate what's going on, are going home and saying things to their kids. So let's see if we can calm the kids down and let them know what's actually happening. Could be helpful.
And maybe, as in sort of the medical model, they need their own kind of social service person, or the children need their own person to help them calm it down. and they need one person to whom they're going so that they're not going to opposing attorneys or one to an attorney and one to the facilitator, that they have a place for them.
Mhm.
And then that can be sorted out and presented to the team.
And Tanya had said during when she was talking, but also in the thing, that we would have an NDA, a non-disclosure agreement from the children. Now, Tanya, if you have the children signing that, do you have them have their own attorneys, or did you just give it to them and have them sign it based on what
We
was said?
gave the option that they should take the agreement to their own attorney, but we did not give them an option to have their attorney participate in the process.
What about if there were, you know, let's say there was, we didn't have that in this fact pattern, but let's say there was a family business, you know, fully structured and
Yes.
an LLC owned by the family of the husband. Then do we bring in separate counsel for either the business or for the children at that point, if they're actually in control of the business now?
That's an interesting question. We had a business in our case, but it was a closed partnership. So, and the children were not involved. Yeah, they were not stakeholders in the business, so.
Yeah. If they were, I think that you are looking at then they are perhaps important parts of this, or at least you'd have to look at the business documents to see, are there, you know, do they have an operating agreement that limits how shares go and all of those kinds of things, to be able to address the business ownership of one of the parties and how that would be handled.
You could mention something that you could have an issue in that area with the children coming into play because of the parents' age, and like if the children are kind of running the business, and let's say Thomas had a business or he had a business he used to own, but he's passed on some interest to his children and they're in control, but Thomas still owns part of it and he gets his considerable income from it. And that income was going to be used to help support Sally on a yearly basis. But he doesn't control the business now. So that his family says, well, we're not going to give you that money, Thomas, because we don't want you to pass it on to Sally. So that's a way the family can come in and present some roadblocks if you have it.
Absolutely. Yeah, no, I think that's important too. And that there again, that's where having the family members understand the benefit of collaborative and agreeing to address the needs on this, understanding that litigation is going to be messy and, you know, how expensive and stressful to this family, older couple it would be, could be really helpful to have the kids involved.
Particularly in terms of the time factor, you know, if you're going to litigate. I mean, it's we're racing against time. To me, it comes back to first principles in the collaborative process. We're collecting all this information from the parties. What does that mean? That means we as a team have to sit down and converse and discuss what's going on, establish a strategy, bring it to the parties and see if we can have an agreement. And then we know whether we're going to what extent we would include the children or not. And maybe it just takes a separate meeting with the children to explain to them, once again, as you've all been saying, the benefits of the collaborative process. Elaine, you still have your hands up?
Well, and then I know Kelly, and we're running out of time, but I wonder if, number one, I love when you talk about the first principles, but those principles are also that if we have competent people, and we have them, we're making these, we're offering these as options and letting the clients give us their guidance and wisdom about how they want us to proceed. And I also think that, you know, that's a big picture. And on a how do you implement it, that the MHP, you know, you, Brad, can be enormously helpful by offering, with their permission, that you be the person who meet with all of these various actors rather than the you know, and then you can come back to the team with, you know, that view of what's going on and
Right.
and work from there.
Yes, absolutely. Tanya?
Yes, and I know we're out of time, but I just want to say the self-determination.
No,
for these
Kelly said we
elderly
can go an extra half hour, so don't worry about it.
Never said that.
So
You're
while
lying right now, Bob. Or Brad,
while we
whoever.
might have competent clients, self-determination is compromised many times in these cases, and they've come to rely on children and others, to help them make decisions. And they're very frequently dependent on these shadow people. So I think we have to make a distinction between competency and self-determination, because they can be competent and not have that self-determination that they need in order to participate, meaningfully in the process.
So that kind of goes into what I was going to say, not to just jump in, but we are almost out of time. And I guess my only other thought was, a lot of what we're talking about involving the children, how that happens and what other professionals might be involved may depend in part on what interests the children actually have. If they are a partner in the business, for example, or they have some right to, the stock under the operating agreement, or if there's a trust, some properties held in trust for the children, and they already, know about it, feel like that's something that's, automatically coming to them in some estate plan that's already been established between this couple, I think their interests are different than just advisors or shadow people. They actually have legal interests in what's going to happen. So I don't know, just something to think about, I guess. So we have like a minute before I give my send off. Does anybody else have something they want to add? Then I would just say thank you everyone for coming. Our July session will be held on July 16th and features my home group, CFL in Orlando. The topic is going to be what to expect when you're setting expectations, the importance of the professional team setting expectations in the pre-meeting. It will feature a mental health professional, Renee Natfig, who is here with us today, and financial neutral Megan Wolf, and attorney Karina Leeson. On behalf of the FACP practice group and outreach committees, I'd like to thank today's presenters. Wonderful job, important information, and thanks again to everyone for attending, and have a great weekend.
I want to thank you all for a good, lively discussion, because as I say, these cases are coming up in my practice more and more. So it's always good to hear from others about ways to help families like this. Thank you.
Yeah, thank you so much, Sharon, for all your hard work.
Thanks for having us, and happy Father's Day to everyone.
Yeah, happy Father's Day to all the dads.